Good afternoon. It's my great pleasure to welcome back to Harvard Law School Justice Stephen Breyer, who will be interviewed here by our own Professor Vicki Jackson. And because you're here to hear them, I will be so brief. But let me just say, Justice Breyer has written a fantastic book. Some of you have read it. I don't usually plug books, but this one I will plug. Here it is, The Court and the World, and the subtitle's important too, American Law and the New Global Realities. He actually will even sign books at the end of this, if you're interested. And let me just also say, the reason the book is so important and so good is not only that it's incredibly well written, not only that it is a window into the minds of one of the greatest jurists living now and maybe in our history, but also because it actually demonstrates to all of us something that I think you all have come to know, which is American law operates in the world. And understanding how to interpret our own Constitution, our own statutes, requires understanding that reality. Vicki Jackson is someone who has devoted her own professional career to that reality, and including her impressive studies of comparative constitutional law and as well her work on constitutional law in federal courts. She is the Thurgood Marshall Professor of Law here, and now I'm going to sit down. Thank you so much for being here.
Thank you, Martha. Well, I endorse everything Martha said about how wonderful the book is. Fascinating treatments of national security, commercial, alien, tort, and treaty claims, First Amendment claims. I want to ask, what impelled you to write this book?
Well, first, I want to thank you for inviting me. I haven't been here in a while. I used to teach here. You know, in those days, this is beautiful. I mean, in those days, everybody was poor. The whole faculty they just had like cubicles in an alley. The students lived in the street under manhole covers. This is fabulous. Thank you. And thank you very much for that introduction. Normally, you write a book, meets his friend. What are you doing? I just wrote a book. Oh, I just bought your book. Oh, you're the one. So thank you very much. Thank you very much, Martha. And why did I write this book? All right. I didn't write it to continue an argument with Justice Scalia. The reviews of it here seem to imply that. I understand that at a political level, and to a degree at a judicial level, there is a disagreement about the extent to which judges in our court or in other American courts should refer to the opinions written in foreign courts by foreign judges. I think that's mostly political. I don't think it's terribly interesting. And I did not write it. That's in Chapter 16. I have to say something about it. And by the time you're at Chapter 16, you should agree with me anyway without even reading what the other argument is. But now I say eliminate that. Then there are a few other more general reasons. In 20 years, I think our courts changed in respect to this subject. There are just a lot more cases. There may be 10, 15, maybe 20% of the cases that you have to know something about what goes on beyond our borders. I'm vague there. I'm not saying it has to be law or a judicial opinion. I'm just saying something. And there are illustrations of that in order to get the decision right. And it's more and more. And it has to do with interdependence. I want to show people what it means in our institution. And I'd say sometimes, it's like if you haven't read, which is probably more worth reading, The Charterhouse of Parma was a fabulous novel, fabulous. And the hero, Fabrice Del Dongo, this opening scene is in Waterloo. He sees the smoke, the guns are firing, Napoleon's rushing back and forth, and he thinks to himself, something very important is happening here. I wish I knew what it was. You see? I hear the word interdependence, there I am, right on that battlefield in Waterloo. I mean, or globalization, all these general words, what is it exactly? So my idea is here to illuminate the answer to that question by providing concrete, very specific examples of what it means for one institution of some importance in the United States, the Supreme Court of the United States. And from those concrete examples, you then can generalize, as can others. Now, there are a couple of other reasons. One is, I think, I want people to know how we decide cases in our court. How? What's the process? How does it work? What am I actually thinking? And what are others thinking? And, you know, half of them think we just take cases on the ground of, oh, what fun it would be to take this case. And that's not it. And, or they think we're junior league politicians. And that's not it either. And so I want them to know something about that. And I suppose at a most general level, I think that there are a lot of problems that you'll face. That's a cliche. More and more. Environment, security, health, commerce, they're all international. And either people will use the rule of law, which is going to be quite tough to make progress in these areas, or they won't. And if they don't, we're in trouble. And because the other ways are certainly a lot worse. Okay, there you have a long list. I wrote it for all those reasons in ascending order.
So I'm going to follow up with a couple of questions, but let me say that after maybe 20 minutes or so, we're going to be inviting, as is our custom, your questions. We're looking for questions, not speeches, so that we can have a real dialogue. So we'll get to that in a few minutes. But I wanted to ask you, Justice Breyer, how new is this? So what I'm thinking is that among the foundational cases that I teach, for example, in federal courts and constitutional law, Martin and Hunter's lessee arose out of a treaty. And in the early years of the Supreme Court, there were treaty cases, there were admiralty cases, which often involved the interests of foreign sovereigns. So how much of this is new and how much of this is just more? Or is it more?
It's more and in different areas. I think if you go back, you have, of course, admiralty is a subject where foreign law will always have an influence, as will treaties. And everyone, 9 members of our court say when we're interpreting a treaty, you look to what other countries do. And, but marriage as the subject of a treaty, abduction of children. Abduction of children? We have to interpret a technical thing on abduction of children. Do you know who knows nothing about it? Federal judges. The people who know something about it are family court judges in the state systems, and it's the toughest job in the system. And Eddie Ginsburg here in Cambridge would tell the people who appeared before him, I hope you figure out something together, because if I have to decide this matter of children, divorce, marriage, and something, I'm going to do a worse job. Really tough job. All of a sudden, the groups who really are against abduction of children and fight against it are over here on this side of the interpretation, and the groups on spousal abuse are on the other side. And they ask us, wow, 3 times in 2 years. And why? Because marriage today and family today is much more than it ever was, a matter that transcends boundaries. That's why. And it's all over the place. And the only way they can deal with it is that way. So we have to learn something in order to deal with it. So, yes, more. But remember, it used to be before Swift v. Tyson, before Swift v. Tyson, under Swift v. Tyson, before Erie. That's good. She's teaching federal court, so I thought she ought to. You got it. But they used to talk about it a lot more because it was the law in the sky. But I've really not written it, in a sense for you, in a sense not for you, Vicki. I'd say, the sense, I don't expect you to know, you'll find some things you didn't know, that I hope. But really what I want to show is other people, that what you're doing is not the subject of a specialized course called comparative law. It is a subject that overflows those boundaries, and it appears here, there, everywhere. So your colleagues, you see, should know some of those things that you likely may know.
So let me just follow up a little bit. One of the things that really struck me, and I did learn a great deal in your book that I didn't know, but you have a chart, I forget the page number, where you identify the number of international governmental organizations
Don't tell them, I'll ask them.
that exist. And so I wondered whether one of the new or changing landscape features is perhaps, and you do write about this, the growth of transnational or international organizations that have adjudicatory and rulemaking power.
This is this Professor Casasi, who's a very good professor, great professor, very great guy actually, but he's now older. But we once went to his apartment in Rome, which was fabulous. But he has 2 apartments, one for his family and one for his books. All right, but he really, and he had all his research assistants. They all went out to count how many organizations are there where they have a staff and they make rules. And those rules can bind people in more than one nation, businesses or individuals in more than one nation. How many are there? Now, how many here think there are more than 50 that bind? Yeah, they could do more than 50, more than 100, more than 500, more than 1,000, more than 2,000. Ah, yeah, we have one good person who knows it's more than 2,000. It is unbelievable. And we, the United States, probably belong to 700 or 800, at least. And what are they? It's not just the UN or the ITO. There's also the Bluefin Whale Commission. And don't forget the International Olive Oil Council. And which one makes rules that affect you every day? Probably affect you more than any other. Have you heard of an organization that has headquarters in Los Angeles, and I think is incorporated under California law, called ICON? Yeah, they make all the rules for the internet. See? And there's the BAL group, where we have all the SEC regulators getting into the room with all the bankers and the other regulators, and they sit there and they decide what rules to have, and then they come back and they promulgate them with notice and comment, of course. But the rule was made there. And someday somebody's going to figure that out. There are articles written about it, but mostly by bankers or mostly by regulators. I'd like other people. This is a general problem. The general problem we've seen it come up, just nibbling on the edges. I'd say if I want to say what is the heart of the matter, I suspect, but I don't know, that it's something going on, possibly like the New Deal, where from the legal point of view, what were these agencies? Where are they in the Constitution? Who's ever heard of them? How do we absorb them into a constitutional system that was built upon different premises? How can Congress delegate authority? Oh, that's a good one. Can Congress delegate authority to 2,000 or 800 or 900 bluefin whale commissions? And if so, to what extent? And under what circumstances? And if you can't, of course, you can't solve the world's environmental problems or the others. But if you can delegate anything you want or do whatever you want, what happened to Article 1 of the Constitution, which says Congress shall have the power to legislate? Not for people that nobody's met on the Bluefin Whale Commission or somebody, you see? Now, those questions are beginning to arise in different forms. When does a treaty become self-executing? Oh, the great case, which we didn't answer the question, I'm glad to say, because we didn't know the answer. The woman, you know, what was Bond? Bond, great case. You know that case? Woman in Ohio, was it? Or one?
I think Cleveland, yeah.
Yeah. She discovers her best friend is having a baby, and the father is the husband of her. This did not put her in a good mood. And she worked in a photo shop and put some chemicals on the door of the quote, friend, quote's house, which she thought would give the friend a rash. And instead, it turned the doorknob red. And so the friend thought something was odd and called the police and the postal inspectors. And pretty soon, before you know it, don't ask me how, you get the federal prosecutors. Don't write down that gesture. But I mean, you don't know what will happen. And they accused her of violating the Chemical Weapons Treaty. Yeah, exactly. And so the question came up to us about whether the federal government does have the authority. You see, now, there are suddenly implications to follow the Chemical Weapons Treaty with legislation that seemed to pick her up and put her in jail for 20 years. Well, we went off on other grounds. not the sort of ground that they wanted. Some wanted, shall we overrule Missouri versus Holland, which says that Congress has the power to enact laws, even if that power is given nowhere in the Constitution but in the treaty provision. Quite a big question. All right, I'm just saying these cases they're coming up. They're there. They're in Europe. They're absolutely there when the German Constitutional Court has to decide whether the German Constitution means that the Germans can delegate all power to the EU or is something reserved. Same problem in Italy. Same problem in Austria. Several constitutional courts in Europe have had to deal with that question, and they've all said there are reservations. But they've never found one. But nonetheless, see, and one's coming up now. So this is a big question, and you will all answer it.
I'll ask one more question, and then I'll go to the eager audience. Throughout the book, you consistently raise concerns about how courts can acquire enough knowledge to be able to know the foreign law issues, the consequences, and so forth. And you call it a knowledge gap. And I wonder if you want to talk a little bit about that, because you invoke in the book the responsibilities of many pieces of the legal community.
That is a big problem that's unanswered. In many cases. Of course, we're not experts. We don't. A judge doesn't know that much law, nor will you, except in one maybe area. But you're here because they're showing you how to find things. They're putting a base in your mind, a big, broad base. I used to think, don't tell I said this, but I used to think that all the Socratic method and stuff was just a way of making it interesting while you actually memorized vast numbers of rules and cases and so forth. It was sort of like bones, for medical students, and they haven't figured out a way to teach the names of bones by the Socratic method. And well, forget that. But the point is, we're dependent on the lawyers. So when I had the case of the man from a student, great case, student Kirp Singh Supong, he was from Thailand, he was at Cornell. He discovered that the same textbooks are much cheaper in Bangkok. So he writes to his parents and says, send me a few. And they sent more than a few. And he began to sell them, and it was a pretty thriving business. And the publisher got annoyed, sued him. Does he have the right to do it? That depends on 6 words or something in this copyright law, American copyright statute. And you know what they mean. They are really obscure. And I go to my office, a stack of briefs like this. Stack of briefs from lawyers all over the world. Asian lawyers, European lawyers, all over the place. Governments are filing briefs, trade associations, consumer groups. Oh, what's going on? This very technical question? And I finally get to the retailer's brief and some others, and the librarians and so forth, and they're saying, well, today's world, copyright is not a matter of just books, or just books even in music and film. You buy a car, the software is copyrighted. Go to any shop you want and look at the labels. The labels are copyrighted. And they say, your decision in this case will have an impact on $3.2 trillion worth of commerce. That's why the briefs were like that. You see? Now, how do we find out? You had to know. You had to know how this works and how it goes on in other countries. What do the publishers normally do? A lot of stuff that you had to know, really. And they'll tell us. They'll try to tell us. And often that's enough, because they'll know, but they're not necessarily going to know how to look up parts. Maybe the antitrust part they'll know. The securities, the parts they won't know unless they're taught here. Unless they're taught here how to look things up, not just here, but what is a prescription, and how do you look it up under French law? And how do you get an expert appointed for the Yahoo case, which is taking place in Lyon or someplace rather than in California? And how are you going to do that? They'll teach you. They're good at teaching that. But that more and more. So we have the 3 parts cooperating. The judges write decisions. The law professors read them, we hope, and criticize them. And put them together with others. And then they'll write articles or treatises, and then the lawyers will read those when they need them, and they will use the ones that are helpful, put them in the briefs, and we'll get back competing studies, or we'll get back what they've done in terms of criticizing our last cases, and we hope we'll write better decisions. And then there's that iterative process. That's how it works best. How do you do it in the national security area? Don't know. Why is that tougher? Very few cases, but very important ones. Why do we have to decide those cases? Because probably most people who read the Korematsu case think it was a terrible idea to take 70,000 American citizens of Japanese origin in World War II and put them in camps, and the Supreme Court said, it's okay. And I just found out the other day, my guess was correct. I thought what they'd said in that conference, and somebody looked it up and read it, and in the conference, Justice Black, these were civil libertarians. Black, Douglas, Frankfurter. He said, somebody has to run this war. It's us or Roosevelt. We can't. So it's Roosevelt. But see, we won't put up with that decision today. Cicero would have done. We won't. And I think we're right not to. All right? Then what do? Why didn't we? We decided 4 cases in Guantanamo. Those 4 cases, everyone's decided for the detainee in Guantanamo. Sandra O'Connor writes, and I joined this, the Constitution doesn't write a blank check. Not in time of war. Not even to the President and Congress in time of war. That's easy. I signed that. Sure. If it's not a blank check, what kind of a check is it? See, and our opinions are criticized by the civil libertarians for that. They say, why didn't you write more? Why didn't you say what they could do and they can't do? And I say, you want to know the answer? Yeah, because I don't know. That's why. All right? And so how? Do we just listen to the government's brief? I'll tell you what they're going to say. They're going to say we need to do this. And are they going to give us facts? Yeah, they'll give us facts. They'll give us as much as we need, as we want, as they think we want to know. So we just say yes? That's Korematsu. Well, if we're off on our own here, how do we know? I think it's important to know what other countries do. I think it's important of having ways of finding out something about the nature of the security problem and the needs, and the lawyers will certainly help. But they have to find out too. All right, that's the problem. Long answer, but that is a big problem.
Well, we could talk for a long time about this, but I want to give our audience a chance to not be shy and to indicate your interest in talking. I'm going to stand up so that I can see hands. I see a hand here. I see another hand here. Are there other I see a third hand over there. Okay, we will start over here and go this way. All right, so this over here. I find geography easier to do than remembering who put their hand up first.
Thank you very much.
Could you say who you are and
Good afternoon. Thank you very much, Justice. My name is Jose Requena. I am an LLM student from the Dominican Republic, a civil law jurisdiction in Latin America. And my question is the following. Would you say that the Supreme Court of the United States often cites judicial decisions, specifically constitutional decisions from other jurisdictions in the world? Because I know that we do in my country and in other civil countries that's done as well, because the judicial decisions are more persuasive than binding. So,
Thank you.
The same, but how often it depends depends on what the issue is. For the most part, you read. What I usually say on this is that if a person who has a job like mine, say a Latin American judge or European judge or something, has a job like mine, the document's somewhat similar to the one I use, the Constitution protects basic rights. Problems are more and more the same. So if he or she has written an opinion, why don't I read it? I might learn something. It doesn't bind me. I made that argument to one of the congressmen, very nice, but he just launched into this enormous criticism of doing it, so I said, I guess that's aimed at me, and he said, yeah. So I said, well, that's why. And he said, so, I thought that was a pretty good answer. Did you like that answer? Yeah, I thought, fabulous. That's what I'm thinking. Great answer. He says, fine. He says, that's fine. Read what they say. Just don't refer to it in your opinion. So I say, not knowing when to stop. I say, well, you know, there are a lot of countries, Eastern Europe or other places, that are trying to build independent judiciaries. It's hard to do. And their own legislatures may not pay them or something. I mean, you don't know what will happen in a lot of these countries, a lot of them. And if we refer to them, that sort of gives, we're an old established court. It may help a tiny bit. And they go in and say, see, we refer to their cases. They refer to ours. We're part of something beyond our own country. That may help them. I thought that was a great answer. He said, fine, fine. He said, write them a letter. Just don't put it in your opinion. And I can't tell you that how much that does. I mean, very good people who are highly intelligent, when I say the reasons for sometimes referring to foreign opinions, they'll say, but this is an American Constitution. So I tried to think of why. Why have I yet nowhere? I mean, I persuade the people who are already persuaded. But that isn't much of a point. Why is he saying that? And I think it's because there's a genuine concern, which I think has to be respected. I respect it. They think that this Constitution does embody very sound American values. And it does, in my opinion, it does. And we don't want to lose them. You see, so we want to preserve these basic American values. So we're nervous about, I say it doesn't bind us. Well, sometimes it does, of course, like with treaties, but then all of us will do it with that. And I do remember that this arose in cases involving the death penalty and gay rights, and those are more controversial. But I said, look, I see your point. You're worried about this influence. Yeah. He says, that's right. That's right. I say, okay. Now, by the time you're in chapter 16, I hope you're convinced, Congressman. I stand it because, you see, my way of trying to convince you is not to make an argument. I want to show you some facts. I want to show you what the cases are like. I want to show you what more and more of the problems are that come up to us in legal form. And I believe that by the time you read this and see what we're actually trying to decide, you will work out that the best way to preserve our American values, the democracy, human rights, and so forth, the best way to do that is to participate, not to ignore what is going on abroad. Because after all, if we ignore it, it'll go on anyway, won't it? And then we'll just be the victims of it. And so what I'm trying to do is show you the problems that will lead you to the conclusion that of course we have to know what's going on. And of course we have to have more knowledge perhaps than we've had in the past about how not necessarily only the legal systems, but perhaps practices of all sorts in different ways and what other people do. In other words, we're sort of in this together. And if he does come to that conclusion, he won't have to read chapter 16.
Let's see, I think you were next. Is the microphone someplace for you to have it? So, great, thank you.
Hello.
And again, please identify yourself.
I'm Tom Snyder. I'm a 1L, and I'm also working my PhD in constitutional history and German history. And I was just wondering, are there any constitutional courts that you look at in particular, and for what reason would you look at those courts specifically, and what do you think they're doing well?
Well, you're thinking of areas outside, say, treaties, or the areas of statutory interpretation where you have to. You're thinking in general constitutional matters, particularly. Yeah. And the two areas that have come up were the death penalty and gay rights, and they were special. And, you know, I understand those are controversial, so when I wrote an opinion on the death penalty, I put in 2 pages about the other countries. Does that make it more unusual or not make it more unusual? And I put 44 pages in of other things, okay? But that's not your question. And the answer is, it depends on the case. Like what I found was quite useful, what I found actually really quite useful was the fact that in Switzerland and in the EU, they think federalism is furthered, the point of decentralization part of federalism. The not too powerful central government is furthered by having only state or unit bureaucracies rather than having a federal bureaucracy. And where we've gone with the New York case and other cases is we've said that the Constitution somehow forbids the federal government, what was called co-opting a state official, by imposing certain kinds of duties on the state official. I wrote dissents in those cases and said it's backwards. If you can use state officials to carry out federal law, you don't need the federal bureaucracy, and that might, in fact, further your objective. What's in the Constitution against that? So I thought that was a good point, but it was just a dissent. And Justice Scalia said, no, he doesn't really know, which is true. I only know a limited bit. Something I could have used, had I known it at the time, was the Dutch system for determining whether a provision of a treaty is self-executing. Is very much like the system that John Marshall wrote about, which is that if the particular provision seems to be aimed at the political branches, like how many troops in Nicaragua or something, or how many frigates, or how many this or that, well, then it's not self-executing. But if it's a detailed thing, can Germans inherit property in Iowa, et cetera? Well, that's self-executing. And the Dutch have that kind of system, too. So that would have been interesting. Or I'm just trying to think of other examples. There are examples. I have to say that it depends. It depends. The cases that do a lot of the courts that do the South African court, when it wrote a constitution, they tried to go around and get what was the best provision in everyone's constitution. It's a pretty interesting constitution. And they write interesting decisions. The Brits are the closest to us, probably. But it's beginning. I mean, there was an interesting case, but too short, two interesting cases in the Strasbourg court. One of them about veils, and one of them about campaign finance. And did I learn a lot? I don't know. Do I learn a lot? What do I learn from? Who knows? And you don't know. Same in writing an opinion. Who will learn from this opinion, and what will they learn? See, but that's the kind of mood. I'm giving you a mood.
Thank you.
And could you pass the microphone over to the student there? And could you stand up and identify yourself, please?
I'm flattered that you identified me as a student. My name is Vivek Krishnamurthy. I am a clinical instructor in the cyber law clinic here.
My apologies.
Which is fine. I'll take the compliment.
Clinical instructor.
My question is about the growing phenomenon of foreign governments submitting amicus briefs, both to the Supreme Court and to other courts. What do you think of that phenomenon? Does it pose any special difficulties for you? Do you give them additional consideration? Because there's a diplomatic aspect to that, right, insofar as diplomacy is the purview of the executive. And when a foreign government submits something to the court,
it's 100% positive, in my opinion, depending on the brief. I mean, if they're going to write a brief that says England is in favor of such and such, that's just like the AFL-CIO saying the AFL-CIO is such and such, or the National Association of Manufacturers in favor of such. Well, fine, thank you. I can read that in the newspaper, or I could guess, actually. And that isn't too helpful. What is helpful when it's a good legal analysis. When Britain and, I think, yes, very interesting, in the Alien Tort Statute cases. And France, I know, it's Mireille Delmas-Marty and former member of their constitutional court, Olivier Dutheil de la Motte. And they wrote an explanation question, are there tort actions for violations of international human rights law in France? And everyone thinks no, but really it's not so true, because you can bring a case in the criminal prosecution, and they'll take criminal prosecutions elsewhere. Or what about suing corporations? Everybody thought, no, but that isn't so clear, you see. But the point is not what the position was. The point is it was very detailed and understandable. And the Brits filed a brief in that case. So did the Dutch. 3 briefs from 3 governments, too. I don't know if the French government did, but 2 briefs at least from the UK and from the Dutch. And in each case, there were a group of lawyers from the same country who filed a brief on the other side saying, no, they're wrong. And of course, the question in part in an alien tort statute case is what kind of rule of law are you going to have in America, which you better be careful because it has to be generalizable. That's one of the factors I think is very important. And there is no Supreme Court of the world that can assure uniformity. And therefore, judges, it's as if the judges in California, and they've had to do this, and they've done it before the UCC in particular. But maybe whether, you think about what will be the effects if everybody adopts a rule like this. That's can't. But judges do it too. The foreign briefs absolutely do it, but say something substantive. And often, very helpful.
So are there other questions? People want to put up their hand? Because if not, I'm going to follow up on two of the issues. Oh, I see back here, there's a hand. Any other hands so that I get a sense in the room? Okay, let's go with this person over there.
Thanks so much for being here, Justice Breyer. I really look forward to reading your book. My name's Liz, and I'm a 3L here. I spent some time in France last semester doing research on the reception of the implementation, I guess, of the Foreign Corrupt Practices Act and its extraterritorial reach. And I heard a lot of people saying, I heard some people saying, you know, this is good, the French government should cooperate with the Americans, we're all trying to eradicate corruption. But I heard a lot of people say that it was an example of judicial imperialism, one of many that's coming out of the US these days. And I suppose my question for you is, as you increasingly make decisions that cross borders, whether or not there's a question of extraterritoriality or not, how do you see the impact, I guess, how do you see the impact on judiciaries abroad? Is there a backlash, or do you think that eventually there will be a convergence?
There shouldn't be. So, I mean, that raises 2 points that are quite interesting and I think important. One of them is there used to be quite a lot of criticism of the foreign reach we were giving to our antitrust laws. All right, now I think there is less because I think we've drawn back somewhat in response to the European enforcement authorities filing briefs in particular cases, and they're having reached executive agreements between the 2 enforcement agencies. And so if you've moved the notion of comity, which is meant stay out of the other country's business, in the direction of how do we harmonize laws that are aiming at the same thing, such as maybe copyright and antitrust and anti-fraud laws in the securities area, you might produce, you're not telling them what to do. What you're trying to do is to get your own law to work properly, where there's the statutory leeway, in light of their law. So that shouldn't produce hostility. But the point where, whether it does or not, I don't know. I'm sure judicial imperialism, in quotes, because I don't, that's a little vague. But I get the point. That what I think is a tricky problem is how things are put. I mean, and there you'll have so many opportunities to worry about this and think about it. You put a thing with it. When I worked for a while for Senator Kennedy, which I loved, I really enjoyed that. And one of the things I learned from him, in fact, I'd say the second lesson. The first lesson I learned from him was the best is the enemy of the good. My law clerks have put all 6 lessons on a cup, which I drink my coffee out of. The best is the enemy of the good. That was true. But the second one was, don't try to get credit for everything. Use credit as a weapon. If it works, there'll be plenty of credit to go around. And if it doesn't work, who wants the credit? Now, what that means in practice and why it's related to your question is I'd see him so often, and we learned that from him. You want a negotiation. You want to get your way. You want to compromise. The way you compromise is to listen to the other person, and when that other person says something you think you can work with, you say, what a good idea you have. What a good idea. I never thought of that. Let's see what we can do with that. And if it works, and time comes to get the credit, as it did sometimes in the Senate, you push the other person out in front and say, he was so helpful on that. She did such a great job bringing us together. Yeah. And the same is true, I think, 110%. When you're talking with lawyers from foreign countries about law, the United States law, maybe we think it is better in some respects, and it is better in some respects. In others, it won't be. And do you want an example of the mood and how it is? Look, this is the kind of question I actually get, and maybe I'm just telling you this because it made an emotional impact on me. Do I have time for
Yes, you do.
All right.
Absolutely.
Because now what you can do, and I described this somewhat in the last part of this book, you can talk to judges in other countries or law students and so forth over this thing. I didn't even know what it was down in the manhole cover I used to live in when I was teaching. But Skype, it's called Skype. All right, so I was in Washington, and I was able to talk to a law school class in Tunis. And there were professors, students, and some people who were writing the Constitution. And after a while, you can develop a rapport, and after we began to talk pretty naturally. And suddenly a woman comes up who's a student, and she says, what do you do about religion in the United States? I mean, do you have, I said, we have freedom of religion. He said, but do you have, suppose, what about, the people who really are very strong? I said, well, you can't establish a religion. He said, I mean, but suppose I said, the light is beginning to dawn. I say, well, you mean that you're worried that you'll write a constitution in Tunisia and it will stop you from going to law school? And she said, exactly. And before you do it, there are quite a few women who were in front of the microphone, and we were discussing it. And what can I say? I say, well, we have these two parts of our Constitution. I can't guarantee they'll work in Tunis. I don't know. I'd say, if you want, I'll tell you that I hope you succeed. And I think most Americans hope you succeed. And I think part of the way that we've tried to run the country is that so there isn't a problem of that sort here. We're trying at that. And I don't know that we have the model. And I think you have to work it out yourselves. Because I don't know what I can tell you that will actually be of help to you. You have to figure that one out. I can tell you, I hope you do succeed. And maybe that helps a little bit. I don't know. You see the kind of conversation? I mean, people have real problems. And maybe we can help with some. But we can't help by just saying, oh, we got it. I mean, sometimes maybe you can. But I think that's the world as it is at the moment.
Looking for hands. Person over here. I've been corrected.
Student,
Please
you're right.
Identify
you're right.
yourself.
Hi, I'm Cameron Clark. I'm a 1L. Thank you so much for coming. Throughout the course of the conversation, I've started to imagine the Supreme Court more as a faculty with an often unstated goal of educating the general public on these issues of the law. With that in mind, I wanted to know a little bit more about how your pedagogy has been influenced over your time at the Supreme Court and how the Supreme Court can be used as a better tool for education, especially as we learn more about other countries and about their methods and their courts, how we can bridge the gap between our knowledge and the knowledge of other nations.
There is an uphill battle here. It's not really a faculty. I'll tell you, it is not a faculty. It absolutely isn't. People do not sit around spinning wheels. Tony, I'm not saying the faculty spins wheels, but you have time for relaxed conversation. No, we're sitting around that table, or we're talking to each other. Every word counts. And be careful of what you say, and listen to others, et cetera, but it is not a faculty. And what we write is for the faculty and others. And people will listen to us and read it, and maybe others will have to talk about it. We can't really talk about too much what we write. It's there as a datum, and others can talk about it. And what we do when we do refer, for example, in those, I put in those cases right here in this book because I want to see how I want people to see how we decided the antitrust case. I want them to see how we decided the securities case. Now, there is a bigger thing that you touch on and are really aiming at, And that is, if you ask Sandra O'Connor, if you ask Tony Kennedy, if you ask me, if you ask anybody in that court, and probably anybody in the government, what is really our biggest problem facing the country, we'll say it's educating the generation after you, and the next ones, in what? Because the document won't work. You know, I've said this only 10,000 times, that I say to the high school students whom I love to talk to. I have the document, you know, I show it to them, and I say, I hope you've read it, but that isn't my point. I can't tell you what to do with your life. I hope you find someone to love. I hope that, in fact, you have a good job, and I hope you work in your community. That's just my hopes. I can't tell you to do that. But, I mean, full-time, not necessarily. Be on the library commission, you know, help on the school board, blah, blah, blah. But I can say, I hope you participate. And I can tell you this, where I have expertise. If you do not participate in the government of this country, as you cynics think you won't, all right, this won't work. And that's something that Adams thought. And that's something that the founders thought. So how do we get out there and tell them that? And the way I try, we sometimes are on these television things. You know, I once did that with one of these books, and Larry King said, you just came here to talk about your book. I said, no. I wrote the book so I could be on television. You see? The lawyers, the law students, you can talk to classes in high school. What do? Why are you in this? What do the lawyers do? What's our system about? Now, that's something I really think. You know, I do the others too, but I mean, that's at the heart of the matter, so it's a good question.
Well, we're getting near the end of our time. We have a hard stop in about 2 minutes so that people can get to their classes. But I want to ask one more thing that I found very powerful in the book. In the epilogue, you invoked Albert Camus' work, The Plague, invoking a very powerful metaphor, connecting really all the themes in your book. And I was hoping you might explain it to the members of the audience.
I say that sometimes because it is emotional, but it speaks to my generation. I mean, if you want a writer who really speaks to us, not necessarily to you, it's Camus, I think, because he lived through that Second World War, and it was our parents or uncles and so forth who were there. And he was in Algeria, and he lived through that revolution and so forth. And when he writes The Plague, which I think is a great novel, and it's about, I want to use it in terms of the rule of law. Why is it so important that we get these institutions right? Well, he says in the book, he's writing about Oran, which is a city in Algeria, which is a metaphor for France. And he says how they got through the plague, which is a metaphor, probably, in all likelihood, for the Nazis and the occupation. And at the end, the doctor asks him, well, why did you? It's a narration by one of the characters. Why have you told this story? He says, I've told this story in part because I want people to understand what they went through in Iran with the plague. And he says, and I told the story in part because I want people to understand what it is to be a doctor. A doctor is a person who just helps. He doesn't have a theory why. He just does it. And he said, most of all, I wrote the book because the plague germ never dies. It just goes into remission. It lurks in the cupboards, in the bedrooms, in the files, in the hallways, for one day to reawaken, and once again, for the education or for the misfortune of mankind, send its rats forth into a once happy city. That's it. I shiver. You know, you have a frisson when you get that, because that's what it is. That's what it is. And so I say, well, what we're doing is one weapon, not alone successful, in an effort to keep that plague germ from reawakening. And it's called the rule of law. And it's an effort to solve our problems, whether they're environmental, security, commerce, health, etc. Under law, a very big challenge, because the alternative to working out that system of cooperation is greater freedom for that basilisk de la peste.
Join me in thanking the Justice.